So I was not present with your lordships. And sorry, my lord, was not present before. Now, my lord, my learned friend, so far as I have gathered, has laid emphasis on two vital aspects according to him. Number one was that under Section 9 of the Act of 1962, the landowners, after acquisition of the land for the user of pipelines, cannot put the land for different other use other than what was done at the land at the time of acquisition. That was his argument. And so therefore, my clients, along with other fish owners, could not have carried on fishing. Two questions emanate from there. Now, Lordship, when it comes to page 51 of the Panchnama, or part of the Lordship will see that way back when the competent authority took possession of the land, after acquisition of the land in 2001, the tank fisheries has been specifically mentioned in the Panchnama. The Lordship will see
Page 51.
page 51.
It's in the table below, page 51 in the table below. On the left.
Oh, volume 1.
Yes, volume 1. Name of crop below, name of crop, kindly see in the table.
Name of crop, fishery.
Fishery. And on the right side, extreme right side below, Lordship sees standing or presumptive crop, it's standing.
Therefore, after having known that there was a tank fishery work being done, and having accepted that, having made payment, now that the payment part of I'll come to later on, is no longer open to the IOC to come back after so many years and say that there was a restriction in the user of the land in terms of Section 9, and so you could not have carried on fisheries. But after having known that we are tank fisheries, they could have ignored us, they could not have paid us any compensation. They have therefore acquisition waived their rights, if any, based on Section 9 of the and they could have taken punitive steps if they were so authorized under law, which they failed and neglected to do so. Number two, my learned friend yesterday, in a hurry, I was unable to show one small part of the documents which I wanted to show to your lordships. That is that page, your lordship, my learned friend has shown the two agreements of the Majis. Now, on the basis of the agreement, the competent authority way back in 2022 passed an award. That award is at page 262.
242.
242, I'm sorry. 242.
Volume 1.
First volume.
First volume.
As well, not what a copy. Page 242. The first paragraph and the last paragraph. The lordship will see. This is the award passed in those two awards by the competent authority. And this award has not been challenged by IOC till date also. And they paid the payment. The lordship will see the first paragraph and the last paragraph. Plus these two things.
May I place one hard both the parties today at offer filing Hajira. It appears from the agreement dated 10th May 2021 produced by Taposh Maiti and Turun Maiti that there was a time period of 45 days which ends on 57/21. The work could not be carried out by IOCL due to natural calamity following by Yash, as mentioned in the agreement dated 12/8/21. The said Turun Maiti and Taposh Maiti has already drawn compensation amount of rupees 71,48,350 only as per agreement dated 10/5/2021. The second agreement dated 12/8/2021 reflects that parties to be paid rupees 85 lakh as a compensation amount for loss of fish, and the time was extended up to 30/11/21 for completion of the laying of pipelines under PNMP Act. Now, my lord, kindly comes to the next page, page 243, my lord, last paragraph.
Yes.
And it turns over, my lord, 243. In conclusion, it has been agreed upon by both the parties that rupees 85 lakhs would be paid to the leaseholders in two equal installments, in which the first installment will be paid during the first week of February 22 and the remaining part thereof during the second week of March 22. The leaseholders agreed to let IOCL to so and so. Then the last paragraph, my lord. I, being empowered under Section 2 of the PNMP Act 1962, do hereby pass the order as per Section 10(1) of the PNMP Act, which is binding on all the parties.
Yes.
So, my lord, on one hand, when there is an agreement, the first period of 45 days is over, then the second agreement, another period is being calculated. That is also the first instance. Because for the second agreement, there was no first calculation of the compensation. In our case also, lawsuit can compare the two situations alike. In our case, there was no agreement in the first place. We presumed that for 60 days, you are paid at the rate of 450 per decimal for 60 days. There was no calculation thereafter. And it could not have been done because for the very simple reason that my learned friend now argued the next issue was at page 197, which he relied on. When it comes to page 197, there is the
Acquittance rule.
acquittance rule. Page 197. Well, you will see from the acquittance rule that there are two payments made. The details of the payments are there. Plus, you will find in vain the time period for which the acquittance rule has been prepared and for how many days. The area of the land is stated to be 3803 acres.
9360 decimals.
9360 decimals. But the period, and that has has been taken into consideration by the competent authority at page 267. The acquittance rule does not bear the period for which I would have understood the word total includes initial period of 60 days and even for the additional 974 days. Now, your Lordship will see at page 267, the competent authority records this finding.
This is my second volume, my lord. 267 is on second volume of the stay application. But on the top plot, on the contrary, it has been IOCL that the acquittance role with regard to the new project was prepared and crop compensation for the period from 1/3/21 228,222, totaling rupees 42,12,245 was paid to the petitioners partly on 3/3/21 and partly on 11/5/21. On perusal of the said acquittance roll, the said period of time, that is 1/3/21 to 28/2/22, does not come to my notice.
So the Lord, emphasis on the word total compensation, irrespective of the fact as to what is the period for which the compensation has been calculated, is totally missing. And there is no agreement to back it up also. All on assumptions and presumptions of IOC. Now, the fact remains, Manoj, that the land was taken possession of on 22nd of March 2020. Admitted fact. And that is an issue which we had made in paragraph 6J of the writ petition. Your Lordship will take it from me. Barkor. Motion to Barkor, reply to Barkor.
Position was taken, paragraph 6. This paragraph 6 of the writ petition, my lord, filed by us, my clients, my lord, that was in first volume, my lord, page 27. And this is paragraph 6, my lord, that on page 27, my lord, running page 27, my lord, internal page 4. First volume, my lord. May I please? That on 22nd May 2020, the said Panchnama was held at the site at the instance of the representatives of the respondent number 1, and the possession of the leasehold land of the petitioner was taken over by the respondents. During Panchnama, your petitioner was verbally told by the representatives of the respondent number 1 that the said project will be completed within a period of 2 months, and accordingly, the said respondents are taking possession of the said leasehold land for the period of 2 months.
This was our statement made in the writ petition. In the opposition, I'll show you what was the reply.
And my lord, the reply in their affidavit in opposition, my lord, kindly come to page 76. My lord, firstly, my lord, this is J, my lord, subparagraph J.
Yes.
They say the plots of the land in which the ROU was acquired for laying the pipelines under the occupation of the petitioner were duly handed over for the purpose of laying of pipelines on 2/3/21. It is clarified that with regard to the petitioner has not handed over the entire area of fishery for which crop compensation has been paid as mentioned above, but limited to 18-meter width of ROU earlier acquired in the year 2001 for the purpose of and also prior to handing over the plots of land, the petitioner was provided sufficient time to retrieve. Then kindly, my lord, this paragraph, the one I placed for your lordship, paragraph 6, has been dealt with by them in paragraph 9, page 80. Page 80, my lord, paragraph 9. And this is not the statements made in paragraph 5 and 6 of the said petition are matters of record. I deny and dispute any allegation, submission made contrary thereto or inconsistent therewith. It is categorically denied that any memorandum was issued under section 50 of the said act as alleged or at all. Paragraph paragraph.
Assuming for argument's sake, the fact remains that on 22nd of March 2020, the Panchnama records that the total land which was taken possession of was 9.38 acres. And this is a fact which cannot be disputed, nor has been disputed, irrespective of the fact that subsequently they say the right of user only for the pipeline which was laid down was a much lesser quantum of land. If that is so, my lord, then they should have only limited their right of visit to only that limited portion of the land, not the entirety of 9.38 acres. I ask the question to myself, when my right of user of the land is it is put into a total freeze for the period of the acquisition for the right of user, I am without business, and that's the reason why the compensation is paid. Now, your lordship will see rule 4.2 of the rules that shows how the compensation is to be calculated. Hand over the
But this will find, my lord will find it at page 170 of the book. Page 170. Rule 4, capital A, my lord, sub rule 2. So, got the page 170. My lord.
Yes.
My lord, 482, my lord, I am reading. For compensation for other damages or loss while exercising the powers conferred under the Act or rules made thereunder, the competent authority shall obtain the Panchnama prepared by a team appointed by him, duly signed preferably by the person interested in the land or by two independent and respectable inhabitants of the locality and the representative of the work execution agency. The said Panchanama shall contain the details of damages or losses caused while exercising the powers conferred by section 4, 7 or 8 of the Act.
The emphasis is on the Panchnama, and whatever is in the Panchnama is to be treated to be the gospel truth unless rebutted by IOC or any of the parties interested. IC has till date, either for the government authority or in the other petition or in the incident petition, sought to challenge the veracity of the Panchnama. And the Panchnama clearly lays down the total area and quantum of land which was taken. It is another fact that IOC has used only a part of it for the right of vision, for laying down the pipelines of Baroni from Baroni.
Holdia to Baroni.
Now, my lord, if this is the situation, it's well nigh to say, my lord, that my learned friend, with all due respect to him, I may have to say that he has put IOC perhaps in a contrary. For the simple reason, on one hand he says, maybe this is correct, maybe it is not correct also. So they leave it to your lordships as to whether or not the total amount of land, total amount of sum which was paid by IOC, that is for 42 lakhs, which we say for the first 60 days, is the total for calculation for the total period of 1034 days, for which I have been dispossessed of the user of my land. Out of that, my lord, 60 days I have already got compensation. This is my case. And 974 days I have not been paid compensation. So therefore, my learned friend, argument is basically that the sum of which 42 lakhs represents the total compensation for 1036 days, which will, in my humble submission, up to less than 100 rupees per decibel. Less than 100 rupees per decibel.
And he himself has said for 450 per decibel.
I think IOC being a
Total number of days is 1045.
1036 days. Out of which 60 for 60 days we have been paid.
Yes.
It commences from 22nd of March 2020 up to
23rd March 2023.
23rd of March 2023.
That's the date of the judgment of the
That is the date of the judgment of the first writ petition of Justice.
Bhattacharya.
And for the period from 20th of March till 21st of July, we were paid compensation at the rate of rupees
450.
450 per decibel, amounting to rupees 42 lakhs,
12,285.
12,385. Now, my lord, the last issue which my learned friend today showed the judgment, if you will see, the judgment I have not of the benefit of going through the judgment, but I must presume one thing, my lord. Actually, whether the facts which just present before the Honorable Supreme Court in 1991 Supreme Court is same as the present. The word of first instance, there is no dispute with that. First instance means it's the first instance. But the question today is whether in our case, it is the case that for the remaining 974 days, whether it's the case of calculation of compensation at the first instance, or in the event, had it been that we have been we sought to challenge the payment of compensation at the rate of rupees 450 for the first 60 days, then I bow down to your lordships that I will have to go under section 10(2) with the district judge. There is no dispute with regard to that. And we have not challenged that issue also before this honorable court also. It's another thing that we may be advised to challenge today, but that will again go to the district judge for the first 60 days. But certainly, Manoj, the Supreme Court, Honorable Supreme Court judgment of 1991 cannot lead to a conclusion that in the event there is no calculation for the number of days for which you have not been paid compensation, that will be treated to be a direct enhancement of compensation before the decisions under section 10(2).
Actually, in this 1991 decision, the question was entirely different.
Yes.
The question was who can be appointed as a competent authority. Question was one particular officer of one of the parties was appointed, and the officer in her own name filed a writ petition in the Bombay High Court saying that, and whether the action of the authority is a quasi-judicial act or an administrative act. In that context, one paragraph deals with 10.1. That is actually obiter. This issue was that the theory of bias was brought in. So Mr. Shantibhushan arguing for the corporation, petroleum corporation, said question of bias doesn't arise because section 10.1 says competent authority and the government can appoint. In that context, they said 10.1 at the first instance. But facts have to be looked into.
Actually, so Manoj, I'll just
That exercise we will do.
I'll do two other things, Manoj. Two other judgments which was written on my learned friend yesterday. One was 2009 and 6 and 2010. Now, Manoj, with regard to Manoj 2010, with regard to whether or not jurisdictional issue and whether or not
Review in absence of statutory provision.
review in absence of statutory provision, not
That is settled.
accepted principle. I am not even having a quarrel with that proposition. Is this a case of review?
No, according to them, determination took place at 10.1. Sending it back to the competent authority would tantamount to review. Review has to be conferred by the statute. There is no review for that.
No, so this is not even a case also. And number two, Malad, 2007, Malad, that is following the age-old principle written by the Honorable Supreme Court in 1954 Supreme Court, page 340. You'll also will take that from Kiran Gopal President 7 Pasmal. That, Malad, insofar as jurisdictional issue is concerned, consent cannot confer jurisdiction. It's a well-settled principle. But did we give consent? If they say that they have given consent, I will say, Maharaj, they could not have given consent, neither did the competent authority draw its strength to adjudicate the matter on the basis of the alleged consent given by both the parties. Says Malad, he was for the first time in exercise of his powers under section 10(1) of the Act, calculated the compensation for the remaining 974 days for which there was no initial calculation of compensation.
You have noted. You have heard also judgment reserved.
Only one sentence, if I can just say, just one sentence. Page 197, wherein 42 lakhs was received, that contains the entirety of the area. It's not any lesser area. Entirety of area, total amount, and 42 lakhs. That is page 197.
Great. Obliged.
No. This doesn't have the rules. This rule is petroleum pipeline. Sir, this book will.
Yes.
Lordship, guy keeps it with you.
No, we'll return it after the,
No. Your lordship keeps it, bro.
because this barrack doesn't contain the rules.
Lordship gives both the copies when not declared. Kindly keep both the copies.
Yes, sir. Please call.
Number 2.
My lord, I am appearing for the petitioner in this case.
My lord, I am for the state respondent, my lord. I am
My lord.
praying for time to file my affidavit in opposition, my lord.
What is this appeal? The tribunal.
My lord, against the order of the learned taxation tribunal.
All right. We'll extend the time limit for.
My lord.
The time as prayed for, the time for filing affidavit in opposition is extended by period of 3 weeks from date. Reply within 2 weeks. 3 weeks.
My lord.
Next.
Number 3.
Right. Lord, the single bench order is page number 16 of the petition, my lord. But I am on the issue whether under the GST Act an order can be passed in violation of section 75(4), that is principle of natural justice, without giving me a personal hearing, my lord. And whether an order can be passed without considering my annual return, although my lord, they have considered it, but without taking the amount into consideration at the time of passing the order. My lord, lordship comes down to, my lord, page number 61, my lord, which is the so-called notice, my lord. The first point, principle of natural justice, my lord. But in the box in the middle, date by which reply is to be submitted 18/10/23. Thereafter, date of personal hearing is NA, my lord. And my lord, they did not give the personal hearing subsequently, my lord. I'll demonstrate by page number 65, my lord. Lord, from the middle, my lord, the paragraph starts from where is it appears to the undersigned that any tax that has not been paid or short paid or erroneously refunded or input tax credit has been wrongly availed or utilized for any reasons other than the reason for fraud or willful misstatement or suppression of fact to evade tax, the undersigned has to proceed to determine the tax and other dues under section 73 of this said act. I therefore proceed to determine, my lord, if an date was provided for personal hearing, my lord, he ought to have mentioned it. But that means no personal hearing was provided.
Where is your reply to the show cause?
But I could not make the reply as because, my lord, these were all in the additional police portal, my lord, as well as my lord, the accountants were changed, my lord, and the proprietor is 82 years old, my lord. But he himself cannot operate any, my lord, but the SOCOS, my lord, the SOCOS, if your lordship comes down to page number
60.
53, my lord, not 60, my lord. 53, my lord. In fact, my lord, yes, 53. My lord, first is liability of outward supply declared in GST 1, my lord. This is my outward supply return, my lord. Statement. Thereafter, my lord, liability of outward supply declared in GST 9, my lord. That is my annual return, my lord. If your lordship remembers Pioneer Cooperative, my lord, in detail, my lord, section 39 as well as rule 80 has been mentioned, my lord, whereof subsequently 9 is the annual return which has to be considered, my lord. My lord, the figures are 8,88,000 in the annual return. It is 8,87,000, my lord, 7 odd lakhs. Thereafter, my lord, the last column, my lord, total liability of outward supply declared in GST 3B, my lord. This was by error. This was where the error occurred, my lord. 29,32,286.31, my lord. My lord, he has directly taken 29,32,000 as the figure. My lord, ignoring that annual return which I had filed at 8,87,000, my lord. And my lord, this in Pioneer Cooperative, lordship has clearly stated, my lord, that is the annual return has to be considered. And what was why the annual return has been inserted in the law, my lord, lordship has clearly stated, my lord. And my lord, the annual return is in page number 44, my lord. '46, my lord. It starts from 44, the annual return in GST 9, and in 46, 6A and 6B. 6A is what I have availed in GST 3B, and B is the corrected figure, my lord. The 3B is 57,91,000, which my lord, but actually, my lord, in the GST 1, I have correctly stated, but only in the GST 3B there was an error, and this error was corrected through GST 9, my lord.
Now, what happened to your writ petition?
My lord, writ petition, my lord, page number 61, my lord. It was said that we have merit. We'll have to wait till the payment of 10% and wait till the this. Well, it was delegated to the appellate authority, my lord, by payment of. Although there was a violation of principle of natural justice, that was section 75(4), my lord.
So already they recovered 6,67,000.
It is recovered, my lord.
That will come to 10% of the.
Roundabout, my lord.
So the learned judge said, give credit to that as pre-deposit and
My
file
lord.
an appeal.
My lord. Well, whereas I say, my lord, I should get an opportunity of being heard, my lord, at the first instance. My lord, and if 75(4) is taken, my lord.
But normally they fix a date for personal hearing.
It has to be, my lord. My lord, the provision of 75(4), my lord, clearly states, my lord, an opportunity of hearing shall be granted where a request is received in writing from the person chargeable with tax or penalty, comma, or where any adverse decision is contemplated against such persons.
So even if you don't ask, they have to.
My
give.
lord.
Why don't we send it back, Mr. Chakraborty?
Well, 10% is with them, my lord. Let me get an opportunity, my lord.
And annual return, he has not examined it, as a result of which that error has occurred.
But it was in front of him, it was considered, my lord. It is not that he has not considered it, my lord.
The difficulty is this, all these periods.
It's true that he did not give any reply.
Well, at the stage of scrutiny also he did not reply. Subject to correction, Manoj. Page 52, he chose not to reply.
No, he has not given a
I
reply.
have not given a reply.
So what we'll do is,
The difficulty means today it is barred. 17, 18 it is barred. Adjudication 3 years has passed. That's why this is a difficulties. If my lord said back, it has to be in accordance with law. And the time period cannot be extended. But that is the difficulties. These are all of 17, 18. My lord, they will come back next year, say that this has time barred. 3 years have passed.
no, he can't raise the question of limitation.
My lord.
My lord, would kindly protect us to that extent.
Yes, he can't, obviously. And where is the adjudication order?
My lord, adjudication order is in page number, my lord, 62, my lord. 64, my lord, in fact. The order is in 64.
Please come. The appellant is the unsuccessful writ petitioner. Failed in this challenge to order passed. This is a order passed under 73. Is it?
73, my lord.
Order passed under section 73 of the WPGST Act 2017 and directing the appellant to pay tax along with interest and penalty. The learned single bench noted that roughly 10% of the disputed tax has already been recovered from the appellant and that an appellate remedy is available under the Act, relegated the appellant to file the statutory appellate remedy with a further direction to the authority to give credit to the amount which was recovered in lieu of the pre-deposit. After elaborately hearing the learned advocate appearing for the appellant as well as the learned government counsel, we find that the adjudication order dated 5th of December 2023 has been passed without granting an opportunity of personal hearing for the appellant. It is no doubt true that the appellant did not reply to the discrepancy notice, nor submitted a reply to the show cause notice, nor there was any written request made by the appellant to afford an opportunity of personal hearing. However, subsection 4 of section 75 states that where any adverse decision is contemplated against a person chargeable with tax or penalty, opportunity of personal hearing shall be granted. Thus, even without a written request, if an order adverse to the interest of the taxpayer is to be passed, an opportunity of personal hearing has to be afforded. Considering the peculiar facts and circumstances of the case, since already roughly 10% of the disputed tax has been recovered by the department, the interest of the department stands protected to the said extent. And the matter can be sent back to the adjudicating authority, namely ACST, Serampur charge for a fresh decision. Accordingly, the appeal is disposed of by directing the appellant to treat the order of adjudication dated 5th December 2023 as a show cause notice and submit their reply within 1 week from the date of receipt of the server copy of this order, along with all documents and details which they propose to rely upon. On receipt of such reply, the adjudicating authority shall fix a date for personal hearing, on which date the appellant or his authorized representative shall appear and put forth their submissions and documents, if any, after which a fresh order of adjudication be passed on merits and in accordance with it. We make it clear that the appellant will not be entitled to raise the plea that the de novo assessment which has been directed to be done is time barred. Since the matter has been remanded by the court for fresh decision, such a plea cannot be raised by the appellant. Yes, Next.
With lordship.
Serial number 4.
That flour mill matter, your lordship is already recorded in detail last time, on last occasion, the order, your lordship. That prima facie section 74 perhaps could not have been invoked in this particular
In this
case.
matter, my lord, I have instruction to pray before lordship to pray for a short time so that we can file the affidavit and come back before lordship after filing of the affidavits.
But in this matter, my lord, they cannot improve their case through affidavit, my lord. My lord, the order is already passed. Section 74 order has already been passed. Now, the reason for invoking 74 is already there in the order. And the basic premise is that, my lord, that if I just, my lord, recapitulate the, my lord, facts of the case, the only dispute is whether I have received more than 60 rupees for my lord, the goods supplied. And their, my lord, entire investigation on the basis of.
Now, have they issued a demand?
No.
Yes, my lord. They have confirmed the demand of 8 crores.
No. Are they issued any recovery notice, bank attachment notice?
No, that they have not issued. But my 5 crore 50 lakh is already deposited, my
The
lord.
learned judge has directed affidavit to be filed because you have also challenged the vires of section 8.
My lord, that I am giving away, my lord. Last occasion I prayed, my lord, that my lord, this issue can be decided on the short, my lord, parameters of whether section 74 could have been invoked in this particular case, my lord, because there are state government notification which says that I am exempted.
They give up the prayer of challenge to section 8, vires of section 8. Then are you required to file an affidavit?
They have made there are certain contentions in the application
My
itself.
lord, the short,
needs to
my
be
lord, issue, my lord, on which
Therefore, if your lordship kindly allows us a week's time, we shall come up with the affidavit within a week's time and matter can be heard out.
my lord, the affidavit means, my lord, all the aspect, my lord, all that I'm saying is.
Affidavit, what you can do is either an affidavit or a written instruction from the department on whatever merits he has done. His contention itself is 74 could not have been invoked. You answer that one page
Very
is
well.
sufficient. We will record this submission of Mr. Sharaf that though the writ petition there is a challenge to
My lord, one more aspect, my lord, they have already.
challenge to serial number 3A of the notification.
That I'm giving away.
That
no, I'm not pressing for that. I'm not pressing that. No, I'm saying, my lord, that they have themselves dropped the proceeding under section 74 in another mill
we
honor.
will fix it on 2nd September, same position. Today we will record that you are not pressing the challenge to serial number 3A.
Correct.
So on that, so either you want to get written instruction or make submissions without anything, it's open to you to do.
So I have to only justify issuance of section 74 notification on the next.
That's all.
Correct, my lord.
We have heard so and so. Mr. Vinay Sharaf, learned advocate appearing for the appellant / writ petitioner on instruction from the appellant submitted that one of the prayer made in the writ petition challenging serial number 3A of notification number 12/2017 hyphen capital C capital T within bracket capital R dated 28 June 2017 as ultra virus to section 8 of the WBGST/CGST Act 2017 and to serial number 3 of schedule Roman 2 of the said act is given up. And the challenge is confined only to the order passed under section 74 of the act. He said submission made by the learned advocate appearing for the appellant is placed on record and such portion of the relief sought for in the writ petition stands struck off. At the request of the learned advocate appearing for the CGST authorities, list
My lord, I am appearing for the state.
union
My lord, I am appearing for the state, my lord.
list on 2nd September in the same position.
Number 5 to 7. My lord, I am appearing for the respondent. My lord.
I'm appearing for the petitioner.
I beg to appear on my.
Yes.
My lord, this is the stay petition has been filed in this case. It's been served several weeks ago. There are 4 issues in this case. I'll start with the natural justice issues.
Hmm.
So the order has been passed ex parte, and the reason is that the executive commissioner who had first taken up the matter, he had given several adjournments, mostly on account of the fact that the assessee had repeatedly requested all the relied upon documents, legible documents, which they had not supplied. Even to this day, they have not supplied. Now, ultimately, the assessee attended the hearing before the executive commissioner. The hearing was concluded, but then the order was not passed. The matter was reallocated to the audit commissioner. Now, the audit commissioner has, in exercise of the powers of the service tax rules, decided an excise case, excise dispute by means of this order, and he has refused to grant an adjournment, which the assessee had asked on the ground that they had misplaced their reply. So they had attended the office of the commissioner, they requested a copy of the reply and a week's time to come for the next hearing. The the learned commissioner directed that the request be placed in writing, which they did. But then that adjournment was not, once that adjournment was, they gave an adjournment, but they didn't give the reply copy. And then when the assessee requested for the reply copy again, there were no further adjournments given. The matter was decided ex parte. So the first issue is, on the strength of the adjournments given by the previous commissioner, can the subsequent commissioner to whom the matter has been reallocated refuse adjournment to the assessee, particularly without dealing with the sufficiency of the request or the adequacy of the request? The second issue was that the notice of personal hearing indicates that the audit commissioner was given the power under the service tax rules, whereas in Excise Act, it's very clear, it's Rule 3 of the Central Excise Rules, which ordain that power. So there is I'll take your lordship through the documents. So that is the second issue with regard to jurisdiction. And the third issue is that this is a case pertaining to undeclared transactions of the assessee, as though that they have manufactured certain goods and cleared from the factory, but they have purportedly not disclosed those transactions. Now, the department's investigation provided a list of consignments which they attributed to the assessee. The assessee went to various local manufacturers and receivers and consumers and obtained clarifications from the receipt suppliers and the consumers, certificates claiming that these transactions belong to them. About the total demand for these 3 parties is about 13 crores. About 6 crores worth of reconciliatory data was given with clarificatory letters from both the suppliers' end as well as the receivers' end. This reply which the assessee had submitted was acknowledged in the order, but in the discussion and findings, there is no actual discussion. So this is the third grievance, because what this does is it interferes with the assessee's right of preferring the normal appeal as well, because it enhances the pre-deposit. And the fourth pertains to cross-examination. There was a request, particularly due to this reconciliatory data being there, which is fundamentally contradictory to the department's allegation. The assessee demanded or requested a cross-examination, which has been denied. Now, your lordship will see the order in original starts at page 55. Now, my lord, the order is quite sizable, so it continues into volume 2 as well.
Yes.
The orders, first page is page 55. The relevant page is, it actually carries on into volume 2 in page 199.
199.
Yes. Lordship will see in page 199, paragraph 21, there is a tabulation. This is the total quantification of the duty for all the three parties. Now, the specific part of the order in volume 2, which acknowledges the notice's reply, is in page 217. So, notice's reply has been summarized here. Your Lordship will kindly come to page 219. It continues into 219. If your Lordship sees the second paragraph from the top of page 219, your Lordship will see the notice is submitted that it has been established that the goods sent by Jamuria as per records found at the transporter's premises actually belong to Sham Cell and Power Limited, Jamuria. The demand of 5.75 crores on Man Steel and Power Limited, based on the assumption that the goods belong to Jamuria, is not valid. Therefore, in the interest of justice, this demand should be disregarded since it has been confirmed that the goods were sent by Sham Cell and Power Limited. Now, 575 is only one. There were two other transactions which were also recorded. If your Lordship sees in the next paragraph, the noticee mentioned in that the demand of 52 lakhs is raised based on a transporter's notebook mentioning Dhanbad, which has been interpreted as Dhanbad fuels. The noticee raised doubt. It is apparent that the transporter colluded with DGGI officials to unjustly demand this amount. Now, what they've said is that these suppliers have claimed these goods to be theirs. This particular transporter who was purportedly involved in these transactions, on the basis of his statement, this entire case has been made out. Now, if the manufacturer and the receivers of the goods have said that these transactions belong to us, this, at least the assessee is concerned, should be gone into and is fundamental to this case. Now, if your Lordship sees in page 226, there's in paragraph L, record of personal hearing. So your Lordship will see the reasons which have been given are provided there. The notices were offered personal hearing on such and such dates. The notices 1 to 7 appeared for personal hearing on 7 June 2023 through their authorized representative, wherein they requested to decide the case based on their written reply, dated 7 June 2023. However, when the notices were given the opportunity for PH again on 15 July and 25th July, these were given by the new commissioner, not the executive commission. They did not appear, and instead they sought a copy of their reply dated 7 June, submitted to the department by their letters 12th August and 13th September. I find that for the sake of natural justice, notices were offered more than 10 personal hearings.
By the other officer.
By the other officers, and that's because the assessee kept asking for the copies of the RUDs. And the officer had concluded the hearing.
No, this 10 personal hearing?
Before.
Before.
That's right. Now, they are trying to defer the adjudication proceedings. Further, I find that the noticee number 8, Gautam Sharma, this is a different noticee. And then in paragraph M, discussion and findings, your Lordship will see that that reconciliatory aspect which was acknowledged in the reply has not been discussed anywhere. This continues from page 172.
Now, did you, in your reply,
yes, my lord.
Did you raise this issue regarding the jurisdictional point saying that he is not empowered in terms of Rule 3?
Right. So the reply was given when the executive commissioner was dealing with it. So the only aspect that was dealt with on the procedural front was that we have kept on such and such dates requesting for the RUDs, you have not provided us. That paragraph is there. But when the audit commissioner came and took charge of this matter, in the notice of hearing, he writes that it is under the service tax rules that I have taken jurisdiction, and I'm accordingly fixing the hearing on such and such date. So then the assessee wanted, they said in their letter that we had attended your office requesting for a copy of the reply, and that we were asked to submit a written request, which we are hereby making. After that, they wrote a second request letter, which was, that request was not granted to them. And that these letters, your lordship will see in page 493 of volume 4. In page 493, this is a portion of the reply which they had submitted. In paragraph 16, I apologize, my lord. It's paragraph 16, my lord, of page 493 of volume 4. The reply is being filed based on the documents made available to us in the captioned SCN. Please note that various annexures relied upon in the captioned show cause notice is either not available or is illegible, and that legible copies of the same would be required to prepare a detailed reply to the caption notice in the interest of justice. We have filed various communications and all the letter references are given. In this regard, however, no reply to the same has been received from the DGGI office. This aspect has not been addressed in the discussion and findings. And thereafter, your lordship will see in page 542 of the same volume, this letter is dated 6 July 2021. This is one of the first letters requesting the RUDs, and they continue. So this is the reason why there were so many dates which were fixed by the Executive Commission. And your lordship will see in page 544, there is another letter dated 17th July 2021. It contains an annexure in page 546. Your lordship will see there's a tabulation of documents which were illegible. And then in the next page, your lordship will see the list of documents which the assessee requested. In page 547, this request was not heeded. Now, if your lordship sees the notice of hearing, the last notice of hearing which was issued, this was in page 569. Your lordship will see in the second paragraph of that letter, it writes, the Chief Commissioner, in exercise of powers conferred upon him by Rule 3 of the Service Tax Rules 1994, read with notification 14 by 2017, has assigned the case to Commissioner Durgapur Audit Commissioner. Now, Audit Commissioner in the usual course does not have jurisdiction. Here they say that there is a specific notification that they relied on to give him the jurisdiction in question. Now, if your lordship sees the notification, now, if your lordship sees, this is the notification which is referred, 14 by 2017, Central Excise Non-Tariff. At the bottom of the first paragraph, your lordship will see the line, the central government hereby directs that powers exercisable by the Central Board of Excise and Customs under Rule 3 of the Central Excise Rules 2002 and Rule 3 of the Service Tax Rules 1994 may be exercised by the Principal Commissioner and the Chief Commissioner. If your lordship sees the next page, the service tax provisions have been provided there. An extract has been given. If your lordship comes to page 4, particularly. So in the appointment of officers, clause 3, section 3, or rule 3 rather, of the service tax rules of 1994, it says the Central Board of Excise and Customs may appoint such central excise officers as it thinks fit for exercising the powers under chapter 5 of the act, which deals with only the finance act. So within such local limits as it may assign to them, as also specify the taxable service in relation to which any central excise officer shall exercise his power. And insofar as the central excise rules are concerned, your lordship will see page 13 of the compilation. And the relevant rule is in page 14, rule 3. And this, your lordship will see, is in respect of the Central Excise Act, under the act which is in reference to the Central Excise Act. So there are, insofar as the procedural
But
aspects
then
of the case.
this
Yes.
notification refers to both Rule 3 of the Central Excise
Yes.
as well as Rule 3.
This is the parent notification. It pertains to service tax rules and central excise
But
rules.
probably he has missed out quoting
It's
Rule 3
possible.
of the Central Excise.
It's possible. It is possible, and whether or not they have that jurisdiction, and if it has been omitted, but he has the power regardless. But on the basis of the the notice of hearing that was issued to the SSE, it is not apparent.
Because once he refers to notification 14 of 2017, we have to go back to the notification and see what is the purpose,
Yes.
intended purpose. And basically, they are all, for internal
Interchangeable and apparent.
internal adjustment of the department, etc., to regulate their business. Court should be very slow in fact, we dealt with one of the matters.
It's a limited point, my lord, on jurisdiction. And insofar as cross-examination is concerned, they've requested it mainly on account of the reconciliatory information which they've
How
given.
does he reject your
Yes,
prayer
my
for
lord.
cross-examination?
Yes, my lord. So the cross-examination rejection is in page 246 of volume 2. of volume 2, paragraph M37 at the very bottom. Your lordship will see there's no reference to the reconciliatory aspect which the SSE had raised. He has simply said that these are authorized representatives. Now, if your lordship sees this paragraph, there is a basic error. At the very top, in the first line, it says notices 1 to said S7 have desired to cross-examine Shri Gursharan Singh, Shri Lakshman Singh. These are the transporters. They are not authorized officers of any company. They were, if your lordship sees the tabulation which I had shown your lordship at the outset in page 199 of volume 1. Volume 2 itself, page 199, if your lordship comes to. So the reconciliatory data was.
Does he go solely by the statement of this Guru Charan and Lakshman Singh?
Yes, because
he
if your
says
lordship.
that
So there are two aspects to the demand. One is that there was an officer of the company who has given a certain information. On that basis, about 50% of the demand has been confirmed. There's another 50% of the demand which they have confirmed only on the basis of transporter statements. Those are the transporters which the SSE had requested cross-examination of. And the denial has been justified on the ground pertaining to the other 50%, for which that officer was deemed to be an authorized officer. So if your lordship sees the request which was made by the SSE, this is in volume 4, page 493. This will become apparent from the request. 474. In volume 4, page 474, paragraph 9, if you page 474 of volume 4, paragraph 9, if your lordship sees, they write very clearly. It is humbly submitted that the aforesaid documents that no credence or reliance can be placed upon the statements of the owners of the 3 transport agencies and one of the employees referred to herein in above. In the event, however, you intend to rely upon the said purported statements, we request that the said 5 persons, Gurcharan Singh and Sri Ranjit Singh, Dayashankar Rai and Deendayal Pandey of Rai Transport Agency and Sri Lakshman Singh, proprietor of Jai Matadi Transport, be made available for cross-examination. So, the demand has been broken up into 2 halves. One, they relied on one of the
page 475 is,
reply copy.
reply.
Yes, that is where the request was made. And this is how he has dealt with that request. He's basically conflated the 2 portions of the demand and given a consolidated justification.
And another point you raised is 6 crores you have offered reconciliation data.
Yes,
That
that
was
they
taken.
had themselves acknowledged in the order. If your lordship sees,
What happened to your writ petition?
so I raised all these 4 issues, and the honorable court summarily deemed them non-maintainable.
Appellate remedy.
The single bench.
No.
And
Saying that appellate remedy is available.
yes, alternative remedies
Here the adjudication is by the commissioner, is it?
by the audit commissioner. Yes.
And the appeal lies to the tribunal.
Yes, in the usual case. Now the assessee, first and foremost, was aggrieved by the non-granting of the hearing. If the reconciliated data was substantial, the assessee could have presented that data more elaborately. Now, they only asked for a week's time before the second commissioner. They had completed the hearing before the first commissioner. And the hearing wasn't given.
So that can also be a ground before the tribunal. But
It can be, my lord. All these are issues, but what this does is the extent of the demand interferes with the right of appeal as well, because 50% of the demand when reconciliatory data has been given by the SSC.
So if to file an appeal, you will have to pre-deposit 7.5%.
Yes, my lord.
That will come to how many crores?
That should come to around just calculate it, my lord.
So roughly you tell, probably a crore, 1.5 crores.
Around a crore, my lord. Around a crore.
Around a crore.
Around a crore. A little less than a crore.
I think it's better you file an appeal.
Very well, my lord. As your lordship says.
Because this jurisdiction of the rule 3 that appears to be a little weak. Cross-examination, there are decisions this way and that way. If you are able to demonstrate before the tribunal that part of the demand was based on the transporter's statement, then denial was bad. Denial of cross-examination of the transporters was bad.
That is their case.
So that you may succeed before the tribunal. And reconciliation or to the extent of 6 crores not considered, matter can be sent back for de novo.
Well, the only
and whether the audit commissioner could have refused adjournment and saying that 10 hearings took place before the
first executive commission.
Probably we'll extend time. By then you ask your client to make arrangement for the funds.
The one thing that is happening here is that what this is doing is it's interfering with the right of appeal. What the petitioner is fundamentally aggrieved by, they want to go to the tribunal.
No, this always happens in high-pitched assessments.
Yes, my lord. And what is happening here also, if your lordship sees the way personal penalties are being imposed. It is almost impossible for they have not been able to file a writ, they've not been able to move before the appellate forum. These are personal penalties which are almost as much as what they're imposing on the company.
Equivalent to
On
that
the
of-
directors, yes. It's impossible for them to.
Where is that computation?
Lordship will see. The order, your Lordship will see in page 251. This is volume 2. So I impose personal penalty of 9.33 crores on Vinod Kumar Agarwal, that's one of the directors under Rule 26. 10 crores on another director, Sham Sundar Agarwal, under Rule 26. 3 crores, 3.94 crores, that's almost 4 crores on Amit Kumar Agarwal, this is page 253, my lord.
But pre-deposit, you don't require penalty to be included.
If it's because these directors have to file independent appeals. So their concern is that insofar as their main case with regard to the reconciliatory information is concerned, at least if it could have been considered, that represents 50% of the pre-deposit.
Please come, sir.
Milord, may I make my submissions, Milord? Milord, in admission to, Milord, in admission.
Manasi, you want the appeal to be allowed?
No, only with respect.
First golden rule of advocacy is to assess the mood of the court.
No.
When
Only one factual aspect, Milord.
when you have to shut your mouth, you have to shut your mouth. You need that's more important than to know when to open your mouth. At times, silence is golden.
Golden, Milord.
This intra-court appeal by the writ petitioners is directed against the order dated so and so and WP number so and so, by which the learned single bench dismissed the writ petition challenging an order of adjudication passed by the Commissioner, CGST and Central Excise, Durgapur Audit Commissionerate, dated 24/9/2024, levying Central Excise duty and penalty on the assessee, its directors, and others. We have elaborately heard Mr. Chaudhary, learned advocate, appearing for the petitioner. Primarily, 4 grounds have been raised by the petitioner. The first being as to whether the audit commissioner would be entitled to exercise jurisdiction and pass the order of adjudication when the audit commissioner places reliance on a notification issued by the board in notification number 14 for 2017 -C E within bracket NT C bracket close dated 9/6/27. It is submitted that this notification has been referred to in the notice of personal hearing, and there is a reference to Rule 3 of the Central Excise rules, of Rule 3 of the Service Tax rules, which is of no relevance to the case on hand, and therefore the audit commissioner has no jurisdiction to deal with the matter. That apart, another subsidiary ground arising out of the same ground is that the executive commissioner was the person who would issue the show cause notice, before whom the reply was submitted, and request letters were made to provide documents, copies of legible documents, specifically indicating as to which of the documents are illegible, and also copies of documents which were relied on in the show cause notice for the first time, and repeated representations were made in this regard, and in the middle of the proceedings, the matter stood assigned to the audit commissioner, and therefore it is submitted there is gross violation of principles of natural justice. More so when the audit commissioner did not grant a personal hearing and declined to accept the request for adjournment. The other ground raised is that the demand made in the order impugned in the petitions is a high-pitched demand, and part of the demand is on the alleged ground of undeclared transactions. When the appellant assessee was able to provide data, reconciliation data, to cover the transaction worth to transaction nearly to rupees 6 crores, which aspect was never considered by the adjudicating authority. The third ground which has been canvassed is that the request of cross-examination made by the appellant, specifically in their reply, requesting for cross-examination of the transporters by specifying their names, was rejected erroneously by referring to the statements recorded by the officers/directors of the assessee company, which would be irrelevant because part of the demand made in the order of adjudication is by relying upon the statement of the transporters. Therefore, it is submitted that the denial of cross-examination is illegal, which will go to the root of the matter, touching upon root of the matter, thereby rendering the adjudication order as void in law. It is no doubt true that the appellant has raised a jurisdictional issue, but such jurisdictional issue requires examination of the facts of the case of the appellant, the effect of the notification, whether the order of assignment was justified, and whether there is any misquoting of the relevant rule, etc., which would require examination of facts, which would undoubtedly require consideration of the factual position. Regarding the aspect as to whether the request for adjournment was unjustly denied, as recorded in the unjustly denied, and that the reasons assigned by the adjudicating authority for refusing adjournment is justified or not, also requires examination of facts. The reconciliation data which is said to have been submitted by the assessee, whether it was considered or not considered, also would require examination of facts. Equally so, the issue as to whether denial of cross-examination was just and proper would also require examination of facts. Therefore, we are of the view that the appellant should exhaust the statutory appellate remedy available before the tribunal. As mentioned above, the assessment is a high-pitched assessment, and the burden on the directors of the company, on whom personal penalty has been imposed at very high rate, will undoubtedly be a difficult proposition, as 7.5% of the disputed demand is required to be paid when an appeal is filed before the learned tribunal. Nonetheless, the statutory provision mandating pre-deposit as a condition precedent for preferring an appeal before the learned tribunal having been upheld by the constitutional courts, the appellants have no other option except to comply with the statutory condition. Thus, for the above reasons, we are of the view that the appellant should exercise the statutory remedy of appeal available before the learned tribunal. Accordingly, the appeal is dismissed. The appellant is granted. The appellant shall file the appeal before the learned tribunal within a period of 90 days from the date of receipt of the server copy of this order. And if the pre-deposit condition is complied with, the appeal shall be entertained by the learned tribunal and decided on merits and in accordance with law. After the submissions, we have heard Manasi Mukherjee, learned senior standing counsel for the department on the above submissions. In the last paragraph, we make it clear that in the preceding paragraph, we have noted the submissions of the learned advocate appearing for the appellant to give a broad eye view of the grounds which have been canvassed by the appellant. But as we have relegated the appellant to avail the statutory appellate remedy, we have not gone into the merits of the contentions and the correctness of the submissions, and it will be well open to the appellant to canvass all points before the learned tribunal and equally open to the department to put forth their contentions.
Deeply obliged, ma'am.
The common orders are 5, 6, 7, 3 months. We'll stop with this, sir.
Milords, before Milords rises, Milords, may I have Milords leave to mention a matter I joined at the first.
Mangreka matter.
Milords, yes, Milords.
Mention one matter.
We'll see what to do. Time is not there, sir. Only 12 days is there.
I understand, Milords, but it's only I'll just only indicate one thing,
Sir,
Milords.
nobody is indispensable. Okay.
Milords.
I know your anxiety. But what can be done?
Milords, I may only indicate now, it came up before Justice Sujoy Paul's court. Milords were pleased to release the matter, noting that it has been extensively heard by Milords.
What will happen after 15th?
Milords, Milords, may I only indicate it's only a matter of clarification,
Sir,
Milords.
against this direction, they have filed an appeal to the Supreme Court, I am told. I don't know. I read
It's
somewhere.
lying in the defect list, Milords. I have checked the status
Alright,
of
next week you list it, sir. Mangreka matter.
I beg you lordship, order.
May-
The contempt heading of this list, today's list, keep tomorrow at home.
You have served notice?
Everything.
And who will appear for the contempt now?
Contempt, my lord, Mr. Ghosh, my lord. I will inform my lord. Kindly, my lord.
You want upgradation?
My lord, I'm
grateful, my lord.
My lord,
Milord, one.
Day after tomorrow. Day after tomorrow.
My lord, I am grateful for the considered my prayer and upgraded the matter. But your lordship clear direction that it should be after condonation of delay application. But it is downside of the list.
Downside, it will come upside.
Milord, I need to mention, Milord, one matter for correction.
Doesn't go upside down. Yes, Manasi, what is it?
Milord, one matter, Milord has pronounced judgment on 14th of May, Milord. Milord, I prayed for a Milord's leave and Milord asked me to come with the application. Milord, that application has been filed. Matter was listed till yesterday at 21, I think number. Milord, may it kindly be listed.
What is the application
Only correction. Milord, only correction to the effect. The last para indicates that there are certain substantial questions of law that has been allowed and some are rejected. That has already been accepted. That part has already been accepted by the FLC, but still that part is allowed. So
all right,
I
then
have
we'll list the application on Thursday.
Milord.
And who will appear for the SSC?
Milord, Senior Counsel Shomi Chakraborty and Bhaskar Shendukar. I have given them notice. Yesterday also they were there to attend the matter.
Okay.
I'll intimate, Milord.
May I be permitted to mention one matter?
Deeply obliged.
Dispose of matter. Lordship, in the order, the appearance of the councils representing Union of India Ministry of Law is not been recorded. Kindly.
When was it disposed of?
5-8. Your Worship, this matter pertaining to
We
the
can-
fees of the advocate.
Who's the advocate?
Your Worship, the learned SG was appearing.
Original say. IT-80.
Yes.
Madhujana. Sir, you show it in days list. Huh? Madhu Ashok Chakraborty, Mr. ASG, Partho Ghosh, Madhujana, TP Acharya, advocate for Ministry of Law, Union of India. Yes.